Good morning, everyone. It is my privilege and pleasure to introduce the African Union Legal Counsel, Hajer Gueldich, who will address a very important topic today, Africa and the International Criminal Court. Hajer, you have the floor.
Thank you so much, Professor. Thank you, dear team. It is always a pleasure to join all of you, as you said, on a topic that is very interesting and important to be discussed. I try to share my screen so that I can, I hope it is there. You can see my screen, huh?
It looks good. Thank you, Hajer.
Yeah, thank you so much. So it was really a wonderful week where you discussed international courts and tribunals, beginning with the ICJ, the ITLOS, coming to our local and regional and continental instruments and organs. And this is really very important that we can, in such courses, disseminate our African instruments, our African touch. And this is really wonderful to see high-level professors and judges and contribute on the African Court of Human and People's Rights, and this idea to merge the African Court plus the Court of Justice that does not come into force yet. And maybe in the continuity of that, I will tackle that today, because I will begin, if you can see my plan here. I'm not able to go. Yeah. So beginning with the introduction, and I will just tackle the issue of human rights in general and how we have a whole institutional and normative framework to try to put in advance the corpus of human rights, but especially the core rights. And we will see that this evolution of international criminal justice from Nuremberg and Tokyo, passing through ex-Yugoslavia, Rwanda, till the actual ICC, was really an adventure. And it was with a lot of challenges, but at least we have this ICC. And for the ones maybe who confuse sometimes, even the journalists confuse a lot ICJ and ICC, it's important that in the second part we highlight what are the different competences of the ICC and what is the process and what are the different cases. When we go through the different cases, we will find that the majority of the cases are focusing on the African continent and African states. When you do the statistics on the 33 cases, the majority are on African cases. That's why there is a reaction from the African status, and they go to what is called these double standards in international criminal justice, and they will try to have their own framework through the merge of the two courts, the actual court on human and people's rights plus the Court of Justice, and they will include the criminal division. However, as I said, there will be a lot of criticism and controversial points on some of the rules. What I will explain is just a personal point of view. It is not the one of AU nor of OLC. Now, me here, I'm as a researcher, and I need also in the next hour to see your reaction, your point of view, how you see the evolution of the international criminal justice, and what we are waiting for the next generation in the field of justice in general. Is this justice fair? Is it just? Or it should be evaluating? I quote Professor Jallo, who said, ICC is still a baby when you compare it to other institutions. Let's be patient. ICC cannot tackle everything. These issues are very sensitive when we come to cross crimes. So let's be patient. There is an evolution, and in our lecture today, we will highlight this evolution. But because we are researchers and because we need that there should be improvement of the system, we need reforms, and that's why we need also to highlight some criticism and some controversial issues. And we can also say, and this is affirmative law cannot be explained and analyzed without a political point of view. And nowadays, when you see these pictures and you are all of you, you go home, you open the television and you see daily these mass atrocities, not only in Palestine, this is just what we see daily, but also, and these are really pictures that become ordinary because we saw them for at least 2 years, the same ones, bombs, people that are injured, that are killed. It become ordinary. It should not become ordinary because the ICC was built on the basis of such images and such crimes since Nuremberg and Tokyo. No pain can qualify what are these people having, and it is shame on the international community that we are still there. More than 30,000 people were killed, and international arena are silent or are not efficient. As I said, it is not only in Gaza and Palestine. You remember 10 years ago, we have the case of Iraq, and you can qualify that also as mass atrocities. The case of Syria, same. So we saw a lot of pictures and a lot of drama and dramatic cases, and we can also qualify that as international crimes. Coming to Yemen, which is a very beautiful country and a very rich country in natural resources. Can you imagine that they have starvation and that these people, they didn't even find how to say food? And this also it continue nowadays with the problem of Yemen. You remember the case of Rohingyas. You remember the case of Ukraine. This is still ongoing. Coming to the case of Sudan, when there is no cameras that spot and that highlight these images, no one will speak about it. So the genocide maybe, or the crimes, I'm not the one to qualify it's genocide or not, or at least international crimes committed in Sudan since 2-3 years. Also, they are at the same time of Gaza, and no one is saying anything about it. And this is here in Africa. And I understand you are from different countries, that even in some of your countries, still other crimes are committed till now, 2025. So we'll ask questions. All this framework promoting, protecting human rights, and especially the core rights, where is it? Is it efficient enough? Why it is not it is not fair, as I said? Why these double standards? So let's try in the first part to put all this puzzle together so that we can understand the context, and after that we will continue with the ICC and the relationship, the nexus between Africa and the ICC. The ones who did human rights courses, all of them, they are aware about the sources of human rights, even if for us Africans, we can have another point of view because we have also our customs, we have our religion, Islam or Christianity or whatever, that also are written, and they came before this Magna Carta or French framework with the Declaration of Human and Citizens' Rights of 1789 after the Revolution in France, or the Declaration of Independence of the USA and the American Constitution. So, you know, I think it is also important that we can refer to our own customs practice in human rights, because these are also sources of human rights. Coming after that, this is the modern generation of, and the 3 generation of human rights that began with the most important charter. This is our, as international scholars, for us, the main reference is the UN Charter 1945 that came immediately after World War II. And if you just begin with the first paragraph of the preamble, it does refer to the people, to the human rights issues. It's very important, nous les peuples, as people. So it's very important to take into consideration human rights, and these are new issues coming with Universal Declaration on Human Rights 1948, plus the 2 conventions. And all the other, it is just I put as examples, but you can understand there is a bulk of other instruments, including the ones considering the issues of aggression, the issue of crimes against humanity, genocide, till the Rome Statute. However, again, the question is, why nowadays, 2025, even if we have all this bulk of instruments, we are still far away, and we still see such mass atrocities in all the continents and daily. So let's begin with an important idea that I need just to put in advance. It's about the jus cogens norms. And for the ones who are not comfortable with the expression jus cogens, I will call it preemptory norms. And there is a whole study of Professor Dirk Clady when he was commissioner in the ILC, International Law Commission, about what are the preemptory norms. Very interesting study where he tackled all these core rights where there is no derogation permitted, not only even one exception, because this jus cogens, one scholar in USA said, it's a bird, it's a fly, it's a jus cogens. They even in the article he wrote, he do not believe in something called jus cogens. However, again, to avoid any controversial interpretation on jus cogens, there is what is called the preemptory norms. And as I said, in these norms, there is what is called the core rights. When we refer to core rights, there is a consensus in the world. And this is even ICJ said that, and even you can refer to Article 43 of the Vienna Convention of the Law of Treaties. These are norms that there is not a single exception that can be allowed. And the first one is the right to life. The second one is the ban of torture. The third one is the ban of slavery. In any case, you can find an exception to that. And that's why I'm sorry for these images for genocide and other practices of torture and other degrading things that you saw already. All the people who saw this picture, they remember them because you see them on CNN, Al Jazeera, etc. All these degrading treatments are prohibited by international law, by conventions, but not only, even by practice, they are prohibited even by themselves. You even do not need to ratify these instruments. They are restricted. Even if you are a terrorist, even if it is a terrorist, the person, it cannot be tortured. Slavery is banned in all cases. There is not an exception for that. Plus the other forms of slavery are all prohibited and banned. So if we agree on this idea that there is a core right that should be preserved, things will be easy after that to tackle the international criminal justice, its evolution, and coming to the birth and the evolution of the ICC. Before we come to ICC, there is a lot of other bodies, offices, organs at the universal level through United Nations for these issues of human rights, beginning from the Office of the United Nations, the High Commissioner for Human Rights, the Council of Human Rights, Security Council, and this wonderful concept of responsibility to protect. When you go through the different reports of Evans and Sahnoun, they are really done in a way, you can see, I quoted, mass atrocities cannot be universally ignored, and sovereignty is not a license to kill. This is the main idea. Even if in the charter you have these principles saying that you have to respect sovereignty, non-interference in the national issues, non-interference in the states in general. However, the idea here is no, there is an exception, and this exception is that we cannot permit mass atrocities, genocide, crimes against humanity, war crimes, and we shut up. We cannot give a license to kill. This is the idea behind responsibility to protect. That at the beginning, 2001, the idea says in case of international crimes, namely genocide, mass atrocities like war crimes and crimes against humanity, it is not possible to put the veto of the Security Council. This is the initial idea. However, 2005, all this come back and we have no reform of the charter, and it is still there. The veto right is there, and that's why you can see that a lot of resolutions coming to the level of the Security Council, they are blocked because of one vote against. So that explains the evolution of the doctrine of Mario Bettati and Bernard Kouchner, who are from France, French scholars, concerning this issue of humanitarian intervention. So the new etiquette is called responsibility to protect. However, did we come here and we include something in the rules that give us the possibility to go and to stop these mass atrocities? No, absolutely nothing. It is the same rules. It is the Chapter 7. It is the qualification of threat of peace and security that allows the Security Council to go there. So what will be the last resort or the last thing that we can go to is justice. So once we have these mass atrocities, these crimes, at least there is a mechanism to take accountable the leaders, the presidents, the chiefs, the ministers of defense or whatever who committed these mass atrocities. That's why here the evolution of international criminal justice took a lot of time. And we can find at both universal level, like the ICJ and the ICC, but also at the continental level. And we have our own African Court on Human and People's Rights. And the judges in this court, even they are doing great. And I think you have already lectured on the role of the African Court on Human and People's Rights at the level of the continent of Africa. And we can continue discussion on how we can evaluate the system so that we can also cover the mass atrocities. I forgot to tell you that we have also the specificity of the Article 4H of our Constitutive Act that allows African countries, after authorization of the Security Council, to intervene in the member states in case of mass atrocities. So all this evolution of the instruments is wonderful, and at least if we are not able to seize these cases, as I said, there was all the evolution of the international criminal justice that allow us at least to see something called ICC. So as I said, the ICC was the last maybe baby that came after a long process beginning from Nuremberg and Tokyo. So you saw maybe the documentary in black and white about all these atrocities in Nuremberg and how the Nazi committed mass atrocities that we can even not believe in, but they were there. Same with Tokyo. So the idea with Nuremberg and Tokyo is how we can do something at an international level. We cannot tackle this at a national level because both countries was defeated in the World War II. We have crimes and we have leaders who should be taken as accountable. That's why it is called international, because the trials were done through international judges. That means that the composition of the tribunal was international. They bring judges from other countries, and this was the first time we did so. You can understand again the idea of the state after the concept of what is a state in modern life with Jean Baudin, till we have this international community with the mechanism of the United Nations. The states are very jealous of their sovereignty. How you can tell them that we will bring your leaders to a trial because they committed international atrocities? So the idea in itself is revolutionary, and it needed, and I think maybe after Professor Benkyoko can witness for that, Professor Virginia Maurice can witness for all the process that was done till we come to the ICC. It was very difficult and painful to convince the member states that we bring these mass atrocities at an international level. And the second step was with the International Criminal Tribunal for former Yugoslavia and the one for Rwanda. Because in the 90s, At these two levels, we had again mass atrocities, women that were raped, torture, millions of people. Can you understand that in Rwanda, half of the population was killed in 4 months? In Rwanda, in Kigali, population was 4 million. 2 million were killed in 4 months. Can you imagine that? So all these pictures again give horror to the international community. That's why it was important and urgent to think about something permanent. These 4 examples and more, you see here the chronology of all the other what is called special course or international specialized course, something like that. So all these ones are exceptional, they are ad hoc, they are called ad hoc. They are specific in time and in their mandate. They are not permanent. However, the idea of International Criminal Court, this is the first permanent court. It is called permanent, so it is there forever, so that it can tackle, and here it will we will have some problem with the competence of the court and the rationale, the ratione temporis, the ratione, etc. Temporis, that means when the court began to work after the Statute of Rome entered into force in 2002, they will not go back. They are not able to see any of the international crimes done in 1997, for example, you see. So that's why the ICC and the idea of the ICC, it begins from 2022 and so on. It cannot go back retroactively. That's why we needed this ad hoc court to tackle the different crimes that take part how is it called, in a period of time where the ICC is not there. But some other special, very special, like the Special Tribunal for Lebanon was there for a topic. It is for the assassination of Rafiq al-Hariri. So the topic, it is different from what we need as a permanent court at the level of international criminal justice. When we come to, you can see here, I need also to put a lot of criticism and to think about it, because we, from our African perspective, we need to see a permanent court. However, it should be a fair court, a just court that tackle all the incidents, whatever and whenever in the world, with the same level of fairness and objectivity. And that's why you can see when he announced it, I put a lot of caricature in my lecture so that you can just think about double standards. When he is announcing Rome Statute, some of the leaders are laughing. They say to themselves, we are not concerned. That's fine. Let them put this ICC. And you know, African courts were very enthusiastic at the beginning with the ICC. And the ICC and the Rome Statute came into force in 2002 because of an African state, it's Senegal. Because of Senegal, the Statute of Rome came into force. And we have this ICC that is its headquarters in The Hague. That's why there is a lot of confusion for the one who are not lawyers, not professional. They mix up ICJ and ICC. So in the second part, maybe we can highlight the role of this ICC in fighting against impunity and what are the core principles when we try to tackle the issue of international crimes. So again, the ICC is different from ICJ, even if both headquarters are in the Netherlands, in The Hague. The ICJ, and maybe this was the first lecture, you know that it is, the component is 15 judges that are elected for 2 9-year terms by the United Nations General Assembly at the both sides with the Security Council at the same time. That's why it's very difficult to be elected a judge at the ICJ. And we have candidates from Africa to be elected for the next mandate of the new judges. And we need also to encourage candidacy from Africa. one of the best lawyers who impacted the ICJ is His Excellency Judge Abdel Qawi Youssef, but we have also now the Judge Dir Tladi, who was previously Commissioner in International Law Commission, and we have other 3 candidates from Africa for the next elections. And you know that this court had 2 competencies in the legal disputes, and these are the contentious cases, and it is about advisory opinion. And in the advisory opinion, why I put here ICJ, because they give a lot of impact in their jurisprudence concerning, for example, the wall case of Palestine. And it was a wonderful case where they tackle, it's a lesson or a lecture of IHL, where they see and they said what is prohibited by international law and IHL, and how human rights should be preserved. And even when you follow the evolution of advisory opinion in climate change, in the issue of Palestine again, and other issues where the South, global South, and especially African countries has to fight so that they can have lead, or they can have historical landmark decision that can bring and will be reference for us in the future. And you can understand that ICJ, for us as international scholars, is really the main reference of the evolution of international law and its principles. Now, when we go to the ICC, it's another style. The ICC holds only individuals criminally responsible for offenses. It is composed by 18 judges within 9 years, non-renewable term, and it has 3 divisions, and they have their prosecutor. And we will go after with some details. What I need also to tackle here, ICC and the Statute of Rome was done in 1998. At that time, the international community didn't know well another actor says or qualified as non-state actors. And these are a new component of international law. At that time, we didn't have deep conversation about that. And that's why the Rome Statute do not tackle the non-state actors. And that's why when Daesh did all these mass atrocities, the prosecutor at that time, Fatou Bensouda, said that the ICC is not competent to tackle terrorist and cases and other offenses coming from non-state actors. And that's why in our Malabo Protocol, we included the responsibility of non-state actors, and this is the evolution and the print or the touch of Africa in its evolution of in its evaluated instruments. Now, this is an old one, but the actual prosecutor, as you know, is Han. So the first one was Moreno Ocampo. The second one was an African, and we have to be proud of this African lady who did a lot for international justice. And just you remember that the Palestine case came from the prosecutor. This is rare that a prosecutor can put in front of the tribunal or of the court a case. So I will just tackle this issue after when I come to the competences. It is just for you to have an idea about Rome Statute at the beginning, 1998, countries who voted against the treaty, including China, Iraq, Israel, Libya, Qatar, United States of America, and Yemen. And after that, the states who signed, for instance, I will just go to the map and you can have an idea about the states who signed, who ratified, and who withdrew themselves from the Statute of Rome. And till here, it's just it is 2008 and 15. This is Palestine who become a member, or for us it is better to say ratify the Statute of Rome. After that, in 2000, before that, 2011, at least the case of my country, Tunisia, we were from the rare Arab countries who ratified the Statute of Rome after Jordan, Djibouti, Comoros, and Tunisia is the fourth only. Can you understand the sensitivity of Arab countries when it is about the competence of the ICC? And again, you can understand that the countries from our side and where there is problem of human rights, of mass atrocities, our countries, our leaders are afraid about this ICC and its competence. That's why we just need to open our eyes and to deepen our analysis and to understand that really we do not need specificities of this Statute of Rome. One of them is about the definition of these crimes, and we do not have time, but if you go to Statute of Rome, very long articles to say what are crimes against humanity, what is a genocide, and what are war crimes. Aggression comes later. The Article 9 bis comes later after Kampala, and they included it. But again, the idea here that ICC and maybe the one who were behind the scene for Rome Statute, there was other international crimes, including terrorism at that time. However, the states were not enough, how to say, they are not ready for other international crimes. The ones for what they are ready, well, at least this one, genocide, crimes against humanity, war crimes, as I said, because they are crimes that there is not a single exception, and it is easy to tackle them. That Statute of Rome, why I tackled the international course of ex-Yugoslavia and Rwanda, because they just prepared the floor to the Statute of Rome. They copy-pasta maybe most of the crimes in this statute, ex-Yugoslavia and Rwanda, and they put them in Statute of Rome. And they also refer to the jurisprudence, and with these different crimes, there is no exception for them. Not only there is no exception for them, but they are said imprescriptible. And this is a very powerful idea when it's about imprescriptible crimes. That means that they will not, I hope you are fine with the, you are seeing it? Yeah,
yes, we can see your screen. Yes, all perfect. Thank you so much, Professor.
Thank you so much too. So I said these crimes are imprescriptible. That means they will not, where is the slide? Yeah, it's here. This principle of imprescriptibility is very important. That means that these crimes, especially, as I said, war crimes, genocide, crimes against humanity, they are always, it ensures accountability even months after or decades after. They will not die. It is not like the human rights issues. For example, I have a house, it is not mine, but I'm there for 30 years old. And come back after 30 years old, and they said, but this is my house. You have no more rights, because this is a practice. No, I said, this is your free, so it is mine. So these are human rights that are normal human rights, as not the same impact like the core rights. These core rights, I said international crimes are generally imprescriptible. That means that they are not subject to a statute of limitations, and they can be prosecuted at any time, even decades after they occurred. But just we need to follow the fact that the Statute of Rome entered into force in 2002, so you will not have retroactivity. You will tackle the different serious offenses since 2002 and coming after that. I said also that, and this is a very important principle, the jurisdiction of the ICC is complementary to the jurisdictions of domestic courts. That means first, it is your country who will tackle these serious offenses. If he is not able or not ready in that time, only in that time, and for these two steps, it is complementary. So it's called a court of last resort. This is an important idea to say that the principle of complementarity come here to say that it is not compulsory to go to the ICC. It is only when the state cannot or is not able. Cannot, that means he do not want to. Is not able means if he is in a transitional period, he's in war, he's under problems, he's not stable. There is no institutions, no justice, no Ministry of Justice. In that time, you can go to the ICC. How you can go to the ICC? This is also other rules. You can go to the ICC through the prosecutor or the state itself when it ratifies the Statute of Rome, or the Security Council. And we come back again with the problems of Security Council, where the veto right can block any possibility to go to the ICC. That's why my third part will tackle the issue on how these double standards of international criminal justice can give a bad reaction of the states who are called small states or non-powerful states. It is not fair that one state can block, and this is a fact. The USA under Bush Jr. in Iraq and Afghanistan at that time committed international crimes. We didn't see any possibility to go to ICC for these cases. More than that, I put somewhere that USA did what is called the immunity. What is I don't know where I put it. What is called they ratified something called bilateral agreements so that they can give impunity to their soldiers, and this is something that we cannot understand. I will find it after. So this is also something that we can criticize the system of international criminal justice when some countries, some citizens, some soldiers are in a better position than others. And this is not something that we can understand. For us, the end of impunity is everywhere for everyone, and we tackle the issues exactly the same. It is not because you are a powerful state will bring exoneration and exemption for your soldiers or for your leaders. It has not a sense, no meaning. That's why I said the reaction of Africa after being at the beginning very enthusiastic was very bad after that. If you can see the picture, the map showing the member states, or what is the state, how to say, the countries who ratified the Statute of Rome. So you see here in general, the powerful state will not go to the ICC and Statute of Rome. And you can see the orange means signatory that subsequently withdrew its signature. And this is the case of Russia and United States of America. The red ones are non-state party, non-signatory, like this is the case of China, India, and other states, even from Africa. And the green one are the state party, and you can see, for example, Tunisia is one of them. And you can see in this picture also that at the beginning, I think more than 36 countries from Africa were enthusiastic, and after that, they began to criticize the system because most of the cases are concentrated on African countries and African continent. And this is a caricature you can see. Most wanted by ICC is from Africa again. So his pin and the different balls, you can see Bemba, Bashir, Taylor, Gaddafi. So this is also what the African countries was criticizing. When we come here, just to zoom on the different cases, as I said, we can go to the table after and we have the chronology. It is, most of the cases are from Africa. That's why the counterpart or the counter response was to begin withdraw from Statute of Rome. And you can see the case of South Africa, Burundi, Kenya, and Gambia. And I think the only country till now who withdrew was Burundi, effectively. Here, the picture of the different, how to say, the different persons on whom there is cases that we pursue in front of the ICC. They are Africans. So criminal justice cannot be colorful, cannot be justice à la carte, as if you go to a restaurant and you pick, you see your menu. It cannot be like that. Justice should be fair, should be objective, should be the same for everyone in the world. So while we have only these pictures in front of the ICC, at least till 2015, because if we go to the chronology from 2002 till 2015, I hope I'm still connected. You can see here,
Yes.
you see Uganda, you see Kenya, you see Democratic Republic of Congo, you see Sudan, Rwanda, Kenya, Cote d'Ivoire, Libya, till Mali, Central African Republic, and you can see here the different persons charged as the status of it, and you can just follow. Go the ones who need more clarification. I do not have a lot of time. Go to the website of ICC. You will have an icon where it is cases, and you can follow on the 33 cases. You can have the status of each of them, and above all, read the cases and read the jurisprudence of the ICC. That is wonderful jurisprudence, evaluating in a manner that you are tackling no more impunity, no more immunity. This is really interesting. However, I said there is a nuance coming since 2015, the case of Georgia, Afghanistan, Myanmar, Palestine. We are no more concentrated on Africa. Plus, most of that investigation on Ukraine, it comes 2022. And here you can see that Putin in 2023 himself and another lady called Maria Belova, there was arrest warrants against both of them. This is in 2023. And this was the first time that there was the ICC had issued an arrest warrant against a leader from the United Nations Security Council that had veto right. And this is something that can nuance all what we are saying since the beginning. More than that, with Gaza, for 2 years, people said, we never saw Israel in front of ICC. Now there is another arrest warrant against Benjamin Netanyahu in 2024. So these are the nuances that I need to bring. And these are good signal and good message that the ICC is doing its best, but it is not the fault of the ICC, it's the fault of the system. That's why in the conclusion, I will ask about reforms. One of the reforms is this Security Council and its veto. These seats permanent for 5 countries who won the World War II, and 90 years after, the context is completely different. And Africa, inter alia, needs its permanent seats in the Security Council so that we can have to discuss all this issue with the countries from Africa and give the African position. So what is wrong with Africa? Why the Africa ICC relation is dead? What is wrong is that at the beginning, with 9 of the first 10 ICC investigations located in Africa, some African leaders have claimed that the ICC is unfairly targeting the continent. And some of the leaders in Kenya especially said, this is Rwanda, they said this Western neocolonialism, and we do not agree on the way the ICC is investigating. And I said to date, I think only Burundi looks set to complete the withdrawal process at the end of 2017. And that's why here you saw here, this is really embarrassing. How can a state sign with more than 100 states in the world bilateral immunity agreements so that they can give the immunity to their soldiers? This is something that is really strange. Can you imagine Burundi or Madagascar do the same, to give immunity to its soldiers and leaders or whatever with all the states of the world? They will not permit us to do so. So this is what I said, the double standards, not of ICC. It is of the system of international criminal justice. And that's why I will come here very quickly to the last part to say a few words about the reaction of the African states to international criminal justice double standards. And that's how came the idea of Malabo Protocol. It came at a time where Omar al-Bashir, at the time the president of Sudan, and Kenyatta, at that time the president of Kenya, had should be arrested, and there was just a warrant from the ICC. So they said, why not? This is the slogan of Africa. African responses to African problems. So let's do our instruments in a way that we can tackle these issues of international crimes locally. And that's how came the Malabo Protocol. So I will just go very briefly, and I think you had already a lecture yesterday on the merge of the African Court of Human and People's Rights, the actual one, plus the Court of Justice that didn't came into force yet, even if the instruments already came into force. But physically, we didn't see any Court of Justice. The idea is not only to merge both of them in what is called Sharm el-Sheikh Protocol. So here you have the sum up. I put here the sum up. Ouagadougou Protocol will bring this protocol to create our African court that we see now, 2008. Sharm el-Sheikh will merge this actual court of human and people's rights with the African Court of Justice. And they said, we don't have enough money, no human resources to do 2 different courts. So let's merge both of them and put them in Arusha. Sharm el-Sheikh didn't enter into force yet. We will do another protocol that will amend Sharm el-Sheikh protocol in 2014. What is amazing with this Malabo protocol is to include the 3rd section, and just pay attention with the dates. We are at a timing where Kenyatta and Omar al-Bashir were in front of ICC. That's why we said, let's block, maybe this is my interpretation. And I refer to my articles, the French speakers, they can see I put 2 articles on this, and they are online, you can go to them. La Cour pénale internationale, une justice trébuchante. And the second article is La future Cour africaine de justice et des droits de l'homme, de la pertinence normative aux considérations pratiques. And this is again a personal point of view. So I go through a lot of articles and I gathered the assembly decisions and whatever, and the response of Africa is to include this international criminal law section so that in case of international crimes, they will be tackled at the regional or at the continental level. We will have our courts, so they will do that. The only concern is this rule 46A bis, and I will come there. So, again, what is the idea about Protocol of Malabo? The idea of Protocol of Malabo is to allow our judges, our court, to tackle these international crimes at the level of Africa, not to go to the ICC. Is there any rule or is there any article in Malabo Protocol that tackle the relationship between the 3 levels? Now we have a new level that is at the continental level. Remember, I said about the complementary principle. They said if at the level of the national level you are not able or you are not or unwilling, you have the level of the universal level. But there is nothing in the text, nor in Malabo Protocol, nor in Rome Statute to give us an answer. And if at the level of the continental level you are unable, can we go to the universal level? There is not this issue of cooperation between the sub-regional or the regional or the continental level and the universal level. More than that, I remember all the discussions here in Addis Ababa this year, the last year, during the summits on the reform of the organs. And the idea of merging the 2 courts is still not something that convinces the member states. So now President Ruto is the leader or the champion of the reforms, and he came with the idea of operationalizing the Court of Justice, the African Court of Justice. They said, okay, we are not ready for the criminal section. Let's do at least the African Court of Justice. Even for that, the states said we are not ready yet. And they involved all the stakeholders to take their time to discuss, including the Court of Human and People's Rights, so that we can see how we can operationalize that. So that's why I said our texts are wonderful. However, the problem is implementation, and are we ready to do it or not? More than that, why I said we are not only not ready, but we are bringing something that is going back with the rationale behind the ICC and the international criminal justice. The rationale is the end of impunity. That means anyone who commit international crimes should be judged. However, you can see here this Article 46a bis that is very controversial, and they put it to be seen on another article of Rome Statute, that is the Article 27. Let's go through both, and we can after maybe discuss. Article 46a bis of Malabo Protocol said, no charge shall be commenced or continued before the court, our court, the African court, against any serving African Union head of state or government, not only head of state of government, but they include also another component that is very controversial, or anybody acting or entitled to act in such capacity, or other senior state officials. So that means you are immuning all the system coming from the head of state till any senior official who committed international crimes based on their function during their tenure of office. So if he is still a Minister of Defense, Minister of the Army, Minister of Interior, a soldier, a senior officer committing international crimes, he should not going in front of the African court. This is the problem. Why it's a problem for me? Because it is in contradiction with Article 27, who put an end to the issue of impunity and immunity, not impunity, immunity. And when you go to the title of Article 27, it is said irrelevance of official capacity, irrelevance of official capacity. That means they said this statute shall apply equally to all persons without any distinction based on official capacity. In particular, official capacity as a head of state or government, a member of a government or parliament, an elected representative or a government official shall in no case exempt a person from criminal responsibility under the statute, nor shall it in and of itself constitute a ground for reduction of sentence. Full point. So in 1998, Rome Statute ended this idea of immunity. Even if you are a head of state, you commit international atrocities, you should go to the ICC. In case, we built a case, as I said, through the three manners. If your state already ratified the Rome Statute, and there is a lot of cases coming from African countries who by themselves went to the ICC, or if the prosecutor had done the case, or if the Security Council deferred the case. These are the three entries point for the ICC. However, there is no an exception. They didn't say if you are still a president or if you, no, there is no exception for that. Article 27 is very clear. That's why the way the Article 46a bis is written, it is as if you are denying this process of international criminal justice. It is for me as if it's a back. I will quote a very interesting, by the way, you can find it online, this article of Dir Tladi, for me is a reference. His chapter, it's a chapter in a book on published in Cambridge University. It's Article 46a bis, Beyond the Rhetoric. Professor Dir Tladi said in his conclusion, and I fully agree with him, he said, the expansion of the jurisdiction of the AU court to include also international crimes has raised much controversy in international criminal justice circles, both diplomatic and academic. Even more controversial has been the decision by the AU to make a provision for immunities of certain officials before the AU court in the form of Article 40a bis. In the back and forth of arguments for and against Article 46a bis, normative policy argument, empirical statements, and doctrinal arguments have been lumped together in a way that can result in a confusion. This confusion has aided in the perpetuation of the hero villain trend in which supporters of the ICC see themselves as heroes and the AU as villains, and the supporters of the AU see themselves as heroes and the ICC as villains. So all is depending on this interpretation of this article and how you see it back with Article 98 of the paragraph 2 of Statute of Rome, and how you will implement it, and what are the exceptions and what are not. And all this behind, again, there is a political will to do or not to do. There is the double standards, there is the power countries and the less powerful. There is a whole circles that are there to interpret and to implement. So it is not only about the normative background, it is more than that. However, in conclusion, I will go back to the idea of the core rights of human rights. How can we admit in 2025 that we kill babies, that we kill people who are civilians, people who did nothing, who didn't begin the war, who are not responsible of the war? How can we kill people because of their homosexual or lesbian or whatever, or because they are black, or because they are Muslim, or they are Christian, or they do not believe in God? How can we kill people because they are not at the right side of the history, or they are with this leader, not with this one? How we can torture people just because of an opinion? How we can rape women, and rape now become a tool of war, become the new wars? All these issues in 2025, and more than that, I see this idea of the black, what is it called? I don't know what is called, the black, in internet, people who will pay to see torture, who will pay to see how you rape people. If it becomes systematic, this is something done under the state. So we are no more in individual crimes. It's what is called mass atrocities. That means there is a lot of ingredients. I have no time to go through. The competence of the court goes after the will, that you are not only to have the will to commit the crime, and this is the moral ingredient or argument, but also it's systematic. That means you are planifying that, like these crimes coming at the at people, you just systematic, you are visualizing them, you are planning to just finish them from earth, Rohingyas case, etc. So how we can still see such mass atrocities, and we find a way, legally speaking, to say that these people, they have impunity, immunity, whatever. So I think, again, when we tackle these issues, we need more than instruments. We need more than criminal, or that comes after. It's a posteriori. Let's begin a priori, preventive measures. And this is the culture of human rights. And this is what we are doing in such seminars. We are trying to brainstorm on our core rights, human rights. If everyone, every citizen in Africa knows what is the core of human rights or the core rights, you will never commit these such mass atrocities. It is for military, for ordinary people, for daily life. So it's, again, a multi-facet problem and challenge. The reform of the system is very important. I said the Rome Statute came at a time that we do not know about non-state actors. Now the wars are difficult and different. It is cyber war nowadays. Just with a drone, you can commit, and you saw a lot of attacks nowadays in Iran, in Qatar, in Ukraine. With a drone, you can just destroy a town, or you can kill people. And drones are just like all the robotization of military nowadays, are something that is beyond the Statute of Rome, because they do not tackle these new challenges of cyber attacks, cyber crimes, robotics. We are still with soft law. We are not yet with issues that are written. That's why the reform of the system to tackle the new issues, the new components of what is a crime, the new tendencies of crimes is very important. And that's why international criminal justice is a process. It cannot just begin and end in 1998. It's a whole process and should continue, not only at the universal level, but also at our level, at the continental level. And that's why Malabo Protocol, even if it did not came into force yet, we can still reform, we can still improve the system. And to do so, I think the best way is that we believe in the system or in the rule of law, in this human rights corps, in democracy. We believe in it and we act in a way that we really believe in it. It is not act in a way that we just need it as a vitrine to say to the world we are fulfilling our obligations under international law, HL, and the Human Rights Corps. No, we need to believe in it really, so that we can end these mass atrocities once for all, because each citizen is already implied in it. It is not something that is strange for us. And that's why there is an evolution even in the curricula in the universities. I remember me as a student in the 90s, I have never had any course in IHL or in international criminal justice or in international law of the seas or in African Union law. Never. It is international law, public international law. That's this course and nothing else. No even international environmental law. All these new tendencies comes after, because there is an evolution of international law. And that's why I think with Professor Virginia Morris, with all these case of seminars, we are trying to say that together we have to think twice about international law, its new tendencies, and we need also to speak the same language. Africans are at a level that they can really become, how to say, they influence the international arena. We have experts, we have our judges, we have our people who can just speak and defend and give the point of view of Africa. But at the same time, internally, let's also be in harmony with what we need for the few generation. We cannot again just give a license to kill for our leaders and say, these are the rules, Article 46A bis. So I think the rationale behind all this should change. This is a very, as I said, personal point of view. I've done as AUCL former member, I was in International Law Commission of AU, and I was given the study on international law and immunities, or immunities and international law. I began something, and there is another commissioner now it is not finished, this study on immunities of and international law. He's continuing with this study, and there is a lot to be done, so that maybe we can do some other seminars to tackle this issue of immunities. But I'm sure that it's controversial and everyone has its arguments to defend its point of view. But again, let's be at least complying with this Article 27 to say that with its international crimes, and with these mass atrocities in 2025, in 2030, in 2063, we should stop it once for all, because this is my understanding of what is international criminal justice. And maybe we can also see new tendencies, new tribunals for climate change and other attacks like the cyber attacks, or maybe we can fix again the Statute of Rome to include all these new challenges of international law, and specifically with international criminal law. Everything is possible. Let's just bring to discuss it. And maybe again, with these law seminars, we are here to explain, but also to listen to the other point of view of the other participants. Thank you so much for listening. And I'm here for the questions, clarification. And thank you for being patient for more than 1 hour listening to me. Thank you so much. I finish, and back to you, dear professor.
Hajer, thank you for that wonderful and comprehensive overview of Africa and the ICC. I would suggest that we give the floor to Ben Kioko, the longest serving AU legal counsel and former Vice President of the African Court, so that he can comment on that wonderful lecture. Ben, you have the floor.
Thank you very much, Virginia. Let me start by congratulating my sister, Professor Hajer, for a brilliant presentation as usual. Just a few comments because I was present when the fractured relationship between the ICC and the AU started. But before I do so, let me also congratulate Virginia and Candice for organizing this seminar and the work you have done. Congratulations. Now, on double standards, honestly, I doubt whether any of us would have imagined that we'll be witnessing in our lifetimes what we are seeing today. It's unbelievable. It's like a movie. Because the founding of institutions such as the UN and the AU was to prevent this kind of situation by getting states together to agree on norms, common values, and standards, so that you don't have a situation where a state can do whatever it wants in violation of international law. But it is happening now, we can see it, and I think Hajer has brilliantly demonstrated that. And I cannot think of a better way to highlight this than what was said by somebody called Udo Jude Ilo, the Nigerian-born executive director at the Center for Civilians in Conflict. And he said as follows: we are now in a situation where the identity of the aggressor or the identity of the victim determines how the world responds. And you cannot maintain an international framework of protection if it's available a la carte. So in other words, if it's Russia, Russia can do whatever it wants in Ukraine, Israel can do whatever it wants in Gaza, etc., etc. And we are not supposed to do anything about it. The rest of the world is silent or is not able to do anything about it. And the question really is, how do we get out of this? And what will be the repercussions and consequences of these double standards in the decades to come? Are we going to expect countries to respect international law and norms when other countries are not? I don't know. Professor Hajer mentioned the case filed by the ICC prosecutor against Israel, and I'm aware of another case that is pending at the ICC filed by over 1,000 lawyers, led by Gilles Divas of France, who passed on a few months ago. Is filed jointly by over 1,000 lawyers from different continents, and is still pending at the ICC against Israeli leaders for what has been done in Gaza. Another a point I would like to make is regard to the bilateral immunity agreements that Professor Hajer referred to, or the Article 98 bilateral agreements. Interestingly, the USA appointed an ambassador at large for war crimes, Ambassador Stephen Rapp, and his role was to encourage state parties to the Rome Statutes to cooperate with the ICC. At the same time, after it had signed the bilateral agreements with other states and had signed the Rome Statute and purported to unsign the Rome Statute. In fact, only 2 states had signed the Rome Statute and purported to unsign, and that is the USA and the Sudan. So you have a situation where the USA was out of the ICC, but was encouraging state parties to the ICC to cooperate with the ICC. Now, at the beginning, before the formation of the ICC, the African state played a very important role towards its establishment. There was a ministerial meeting in Dakar, which was a preparatory meeting to the Rome Statute meetings. And the OU Assembly adopted a decision requiring member states to massively participate at the Rome Conference. Another issue I'd like to highlight is that in the first African Union Strategic Plan, 2004 to 2008, there was a requirement by all states for universal ratification of the Rome Statute. And many of you will know that when you have a strategic plan, is adopted by the Assembly of Heads of State and Government after negotiation by ambassadors, experts, ministers, and so on. They called for universal ratification of the Rome Statute, and that will show you the kind of support that they had for the Rome Statute at the beginning, 2004-2008 strategic plan. The AU and the ICC had established a very close working relationship. Any report going to the UN Security Council from the prosecutor was shared with the African Union through the Office of Legal Counsel 2 weeks before submission to the UN Security Council, so that in case we had any observations, we could share them to the prosecutor. And the prosecutor would come to Addis Ababa a couple of times every year for consultations, and of course we'll meet him during the ICC annual conferences, Assembly of State Parties, etc., etc. Now, when the prosecutor decided to apply for an indictment against President Bashir in July 2002, the OU summit was the African Union summit, was meeting in Sharm el-Sheikh, Egypt. So the prosecutor Ocampo sent his deputy, Fatou Bensouda, to meet with the African Union chairperson, AU Commission chairperson, in Sharm el-Sheikh, Egypt, to convey this decision. And this was 2 weeks before it was officially announced. The application was officially announced. Now, the chairperson asked the deputy prosecutor to convey his request to Ocampo to delay the application as the timing was wrong. At that time, peace talks were ongoing in Doha, Qatar, between the government of the Sudan and the Justice Equality Movement. It was also a time when the African Union mission in the Sudan, and basically based in Darfur, was in the process of being converted into the joint UN-AU peacekeeping mission, UNAMID. And this process required the full cooperation of the government of the Sudan. So you have this indictment coming at a time when there are peace talks in Doha, and there's this process of converting the AU mission into a joint UN-AU mission in the Sudan. Now, following the application and the indictment that followed, the Peace and Security Council of the AU expressed regret at the timing of the decision and requested the UN Security Council to implement the provisions of Article 16 of the statute, which it failed to do. Now, Article 16 grants the Security Council the power to request a deferral of an ICC investigation or prosecution for a renewal period of 12 months. Acting under Chapter 7 of the UN Charter. So the AU did not request that Bashir should not be prosecuted. It just requested for deferral of the indictment for 12 months. The UN Security Council did not do so. And as a direct consequence, the peace talks in Qatar collapsed. The AU had also started a process of negotiating an MOU with the ICC. But that process was never completed, and the MOU was never signed. And there were a number of reasons for that. We disagreed on the provisions of that MOU. The ICC wanted an MOU with the same provisions as the one with the UN. And the one with the UN provided that if the ICC prosecutor requests for any documentation, for example, from the AU chairperson, and documents which were, for example, available with the mission in the Sudan, the chairperson had to release those documents. And then if there were issues about how they should be used, that can be included in the submission to the ICC prosecutor. And we said, no, we can't do that. The chairperson must have the leeway or the flexibility to say, I cannot release these documents right now because of ABCD. And as fate would have it, we learned from the UN Under-Secretary General for Legal Affairs and Legal Counsel that in the Thomas Lobanga case, the ICC had requested documentation from the UN. The UN had released the documentation. with the express provision that these documents are to enable you to investigate. They are not for use. It's just to show you what kind of evidence exists, but you cannot use them. And Ocampo being Ocampo went ahead and used them exactly as they were. And the UN was upset. And when we learned about it, we told the UN, we told the ICC, sorry. And then Bashir happened, and the agreement was never concluded. To finish my remarks, just to say this, I believe that the relationship between the AU, which was really a very good relationship with a lot of support from the African member states, was fractured, I think, first because of the personality of Ocampo. Ocampo, I met him, I don't know, maybe over 12 times in Addis Ababa at the Assembly of State Parties meetings. Ocampo was a showman. When the trial chamber allowed him to indict Bashir, from his own colleagues, we learned that colleagues had advised him that they didn't have sufficient evidence to do so. And then he did a party and told them, now we have this approval, let's now go look for the evidence. That was Ocampo for you. I believe that Bensouda was a much more balanced person, very competent. If she had been the prosecutor, I don't think this would have happened. And I think this also shows the problem with the structure of the ICC, because there's no limit to the power of the prosecutor. If the prosecutor says, I'm going to indict so-and-so, there is no outside review mechanism to tell him, wait a minute, the evidence that you have is not sufficient to go this route. It isn't there. So the prosecutor is really the final say on this. And I think that's where the problem started. And then, of course, you had this situation where, untenable situation where you had all the cases against the continent. There wasn't any from anywhere else. No attempt to investigate Gaza or anywhere else, Myanmar and other places around the world. Thank you very much. Or even Afghanistan. Thank you.
I was not aware of the background history. And as someone who spent 20 years working on international criminal law, including the Yugoslav statute and the ICC, what a tragic lost opportunity. And the idea of the ICC was to contribute not only to justice, but to peace. And in my opinion, from what I've just heard, it failed to do so. And I think that that is really a tragic lost opportunity. Turning now to the questions. The AU accuses the ICC of targeting Africa, yet many of the court's African cases were self-referrals by governments on the continent. Doesn't this narrative of bias serve more as a political shield for leaders than a reflection of reality, and in the process undermine the voices of victims who desperately seek justice?
Yes, thank you so much. First of all, to Judge Benkioko, his institutional memory, and when he speaks, as you said, we are not aware about a lot of details, but it is important that we can be aware about them and all the time to put everything in its context. That's why it's very difficult just to give argumentation without having this background. So thank you so much for witnessing and for your clarification. Very interesting.
Hajer, can you turn your camera? Hajer, can you?
Okay. Sorry.
Please continue.
Yeah, I saw a lot of very interesting questions, and I tried, when I explained the point of view of, as I said, of a scholar who is independent, objective, etc. However, as I said, in answering, let's just try to put everything in balance. So I will go through them in a way that I will tackle most of them in generally speaking, not only the question you raised. So if just I may again and again highlight the issue of political will, if there is not political will, nothing will go, not only from African perspective, but even from the universal perspective. So I think this issue of selectivity of international law is really harming the whole process. So if we believe in it, we go to it. If we do not believe in it, we cannot be schizophrenian. We ratify just to be a vitrine, good scholar in the queue, or just to select or to do some kind of instruments that will block as the article of impunity, for example. So if this is the main important idea in the whole questions is about this balance between the interests of the states and the law and the mechanism of protecting human rights, and especially the core rights. If all of us, we agree that there is not any exception to mass atrocities in that time, just we need to put the best instruments ever, so that we can, at a preventive and committed and a posteriori, we can tackle these issues. Again, so just I will try to go in a way to gather all of the questions together. When it's about has the ICC been fair to Africa, and should it still be trusted for the global crisis, especially Palestine? I think that the AU, in general, there is a difference between AU as an institution, the organization, and the AU member states. So as organization, we have to respect the ICC's mandates, but there is a call for greater consistency, and this selective enforcement of international law, especially in situations like Palestine, undermines all the trust in the system. And the Africa member states, they remain engaged and they advocate for ICC reform, including the limiting United Nations Security Council political influence. And that's why I said reform of the Rome Statute and reform of the system of Security Council and the system of the Charter. There is also a consensus among the legal scholars that the legitimacy crisis of the ICC stems partly from its structural dependence on state cooperation and Security Council geopolitics. And this is really the true universality requires that all crimes, regardless their geography or whatever it is, they can be persecuted with equal vigor. And about how we can cooperate or not, again, when you see these cases of Vladimir Putin and Benjamin Netanyahu, if they will go to states who already signed and ratified, the states cannot cooperate. They can not cooperate. So in case of no cooperation, they will do nothing for these criminals. And the other issue, they will visit states that never ratify the text, and that in that way you can do nothing for them. And the issue of cooperation is very important, and this is challenging the ICC itself, because you can have all these rules, but at the end, as I said, these leaders, they are free. They are just not behind the scene. Is the Malabo Protocol a political tool to weaken the ICC due to impunity provisions? And this is also the issue we try to tackle. Okay, we go because the ICC implementation state of Rome is controversial, so let's do our own solutions. But in our own solution, we put this Article 46A bis that block the system. And someone asked the question, is there any mechanism to see what are the coordination between the national, the continental, and the universal level? There is none. For instance, this is a question of interpretation. And in my mind, in my article, I said that we can have the same philosophy and the same analysis. If at the continental level you are not, you cannot, or you have not the will, we go to the universal one. So this will not block that, I think. So in all cases, the universal jurisdiction is the last resort, and the Africans cannot block the ICC in this case. And this is, again, it does not negate that the AU's commitment to justice, but it does reflect a phased approach and does prioritize the domestic remedies, peace processes, and future accountability. And that's why we even do not need this universal jurisdiction. If we are serious enough at the level of national level, let's improve our local laws and how to say our instruments, our national laws in a way that we can prosecute in case of international crimes. And I see very rare constitutions in Africa that include these international crimes. For example, if the chief of the president or the chief of the government commits any of international crimes, no more impunity. No more immunity. I see very rare constitutions at the level of Africa tackling that, but I think it is very important. So the AU does not seek to weaken the ICC, but it does offer an African-owned and contextually sensitive affirmative and alternative. And from an academic standpoint of view, we think that maybe while the scholars' view on the immunity clause said they are undermining accountability, others argue, and this is the politicians, that no, this is our right, and we are just sovereign, and all the international law is based on sovereignty and on the political will. If the state or the government do not need to ratify this instrument, in no way it can be binding to it. So the key is whether the protocol eventually does deliver credible prosecutions and victim-centered justice, not merely legal architecture. And I think, again, it's a whole. We cannot just tackle the issue from a narrow point of view. For the maybe two last questions, is it contradictory for African states to criticize the ICC while refusing to ratify Malabo Protocol? This is really relevant, really very interesting observation. And this highlights, as I said, the legitimacy of the whole system, and that's why the Malabo court is not just symbolic, but it should be effective and credible. And we have a role as scholars. Someone said how we can encourage ratification. For instance, only Angola ratified, and this is not normal, that just we create our systems and we do not believe in it. And we have, as I said, as scholars, at least to do this sensitization for our different texts. The double standards, I think it is there. We cannot counter it. The only possibility is to reform the system, Security Council, and it's we have not to wait for World War III to have a new charter, because this one, I think it is no more updated and it does not speak to the new challenges. Position of African Union on human rights violation in Gaza, it is very, very well known, with different assembly decisions since not only on Gaza, since the Palestine case, we have all the time from Peace and Security Council resolution something on the case of Palestine. And last year, they gave mandate to the Office of the Legal Counsel to go in front of the ICJ for the advisory opinion in February 2024. And they gave us another mandate this year to go in front of the ICJ in the case in May 2025. And we are waiting for the advisory opinion, the second one on Palestine case on the issues of humanitarian aid. And you can understand that if the Office of the Legal Counsel, if the Legal Counsel will go in front of the ICJ to speak with the same voice of African countries to defend the case of Gaza, the case of Palestine, that means that all the 55 member states speak the same language and they are solidaire, because we had already suffered for long centuries from mass atrocities in our continent. And that's why the theme of the year is now reparation through justice for African descendants and for African individuals, because of all these atrocities we suffered from, beginning from slavery, colonialism, etc. This is the theme of the year, and there is a decision that will bring it as a decade. It is not only the theme of the year, but it will be for 10 years. And one of the idea is to go to the ICJ to ask for an advisory opinion, how we can seek reparation on this issue. Also, the issue of challenges of international criminal court. One is asking what they are facing. The most challenge is the non-cooperation. There is ratification first, And to ratify, one of the questions already brings the answers. It is because of the NGOs, the civil society, the scholars, the mass media who can influence so that the country will go and ratify the Rome Statute. But there is another issue, not only the issue of ratification, the issue of non-cooperation. And this is another challenge. The other challenge is personal. Can you believe that the prosecutor, for example, Karim Khan or other judges are under threat from the USA? They do not give them visas. They block their accounts. They threaten them personally. Even Mrs. Fatou Bensouda taught us about a lot of stories. And she's really a very courageous woman, how she just struggled so that she brings the case of Palestine. Can you understand that they threaten their children, their parents, her parents, etc.? And this is the same with the actual judges. When you just face these powerful states, we cannot understand that it become threatening yourself as if you are doing wrong, but you are doing the right thing. You are trying. And it's a shame for the international community to be silent in face of such mass atrocities that we see daily, not daily, each second. And we see that our tools, our instruments are just paralyzed because of a veto right, because of double standards, because of subjective interpretation of the rules, because of the power of some states. All this is frustrating. That's why, in general, the students, they feel really very embarrassed when they have all these lectures in international law, HL, and they feel it is not effective, it is not efficient. It is really something that is very embarrassing, even for professors, when we see all these images daily on Al Jazeera and on CNN. So I think, again, maybe I think we can just spend hours because the questions are very interesting, and each one, especially the technical ones, need a lot of time. However, I think just last maybe message or last call is just let's try to seek this justice and this objectivity in improving our different texts, but also not being schizophrenic. We need to believe in ourselves, in our texts, in our framework, in our institutions, in our organs. We need to improve, we need to do reforms, but above all, we need political will. It is not just for the others. I'm concerned also. I have to think twice before I give the order to soldiers to kill innocent people, babies, children, whatever, because it is just not. You can see the different cases. Universal jurisdiction was a very interesting question. France and Germany for some Africans, but also Syrians. And this issue can be also complementary to all what we are saying. If ICC and ICJ are limited, we can also go through the universal jurisdiction. That means the states who ratified the Geneva Convention and their protocols, they are able to seek for justice for people who come to their, you can see the Syrians, people who go to Germany for hospitals, for clinics, they go directly to the jail because they have what is called the universal jurisdiction, and the national courts there, they are able and competent to sue these persons for mass atrocities. However, again, you can see the double standards. And I remember Belgium, the case of Belgium, it's about the case of Israel when they tried to do this universal jurisdiction for Sharon. And because of a lot of interference and a lot of pressure, they did not they end the case. So again, all these issues are under the expression of political will. And I'm optimistic all the time. I told myself, the new generation will make the difference because they suffered as I'm suffering when seeing all these pictures daily. How can we eat when people are under starvation for more than a month, 2 months, 2 years? They do not eat anything. Can you imagine people they eat leaves and sand? Can you imagine that you persecute people, they go just for some food, and they just they have their legs or bombs on them. Journalists, you can see indirect because they're just trying to fix these issues. The sophistication of the arms nowadays, it gives a lot of other implication, refugees, displaced persons, environment issues. The atomic the bomb, that is the most impressive one, and we do not know, maybe as I said, are we able to go to a third world war, to be aware about what will be next, and what about our kids, or the future generation, what we will inherit. All these, I have children and they are seeing all these pictures daily. Can you understand our moral, and we feel paralyzed, we can do nothing. People who do not trust anymore international standards and international law. But again, I think we need to be involved in all stakeholders. We do not have to shut up. And you can see a lot of people in the roads when they can, millions of them in the world, in the whole world. You can see the demonstration, because people understand that this is unfair, that this is unprecedented. We never saw that. And can you understand the number of the bombs on Gaza? It is the equivalent of 3 atomic bombs. So this is just for the statistic of Gaza, but you can go to Sudan and other countries here in Africa, and all these implication, morally speaking. When I say rape of women, can you understand that these women are forever, they can have this harm forever? It is not only physical, it is moral, it is sexual, and it can implicate a lot of suffer for the family, for the babies, and whatever. So again, I need just to give this message of hope, and this message of shared responsibility. Everyone from each side, as scholars, diplomats, AU, judges, the people who do in mass media. You sometimes on YouTube or on TikTok, 2 seconds, you can do a lot, and you can influence a lot just with the video, just a picture, just something that just give the impression that yes, we can do something differently. We have never to stop the fight. We have never to give up. It is a long, again, Charles Zalou said, let's be patient. Let's not just hurry up. This process will take time. When it's about international crimes, countries that will not be easily believe in it. It needs that we bring a new generation believing in what is rule of law, so that we can tackle these issues prevently, not after it comes. But definitely, thank you so much, Professor, and both of you, Benkyoko and Virginia Morris, to give us opportunity to speak about it. You can go through the details when you visit the court, the African Court of Human and People's Rights, see all the evolution of its jurisprudence, go to the ICC and the ICG websites and see the evolution of the different jurisprudence that brings a lot. So now all what remains is the political will, is this really unbalanced picture of Security Council, where there is just 5 permanent who are blocking the decision for the whole community. Not only the 5, one is sufficient to block the legitimacy and legitimity and the efficiency of the whole international system. Maybe this can be one of the reforms that should come very soon, and African countries, African group in New York can do the difference. And that's why the Office of the Legal Counsel, we did something the last week, New Jersey and New York. We bring together the African group and the African countries, and we dedicated hours to see what we can put in this draft of International Convention on Crimes Against Humanity, and other tools and instruments coming from the 6th Committee, the studies of International Law Commission. You can see that when we speak the same language, we can become rule makers, as all the time said distinguished Professor McCann. We can become rule makers, not rule takers. It's your time, it is your role. It is, we have to be at the good side of the history, not at the bad side. And I think We don't have to shut up. We have to continue saying, trying, improving, reforming our systems, and above all, speak the same language, be united and be solidaire in such cases. It's really bad. I feel very bad when I see daily pictures like that, more than 2 years, and silent of international community. What we are expecting, that 2 million are finished so that we can move, this is not tolerable. Sometimes I see the news, just one dog or one cat killed or tortured. You know, a lot of NGO, civil society are just, how is this possible? A cat or a dog is tortured or killed, but how about civilians, people's innocent babies? So no one care about them. Not only again in Gaza, I'm just tackling all the countries where there is mass atrocities. And for me, this is what my professors told me. These are Justice norms. There is no derogation to them, and all the issues are possible so that we can put a final point to these mass atrocities. It depends again on the political will, but not only. I think everyone has to take its responsibility, and it is the moment to do so. Thank you so much. And I will capture all the questions and answers. I give you my email, and I can engage personally with the ones with whom I didn't give answers. And again, I have my articles. I will put just the links on the questions and answers. I remain available, and thank you so much, Professor Vigia, giving us the opportunity to express ourselves and to tackle these issues that are the modern side and challenge of international law, and we need to see them seriously and to deepen and to dig more our comprehensive framework, but also our tools of implementation. Thank you so much. Back to you. Thank you.
Hajer, thank you for those enlightening and insightful answers to the many wonderful questions. This has been another powerful lecture for me, both your lecture, your answers, and the intervention by Ben Kyoko. I would like to move to another topic, and that is the coalition. And this very much follows on the comments that you have made about people taking responsibility to do what they can to make the world a better place. I am delighted that you and Ben are both here today. As the participants know, I consulted with both of you after the participants told me they wanted to do something about the Convention on Ending Crimes, Ending Violence Against Women and Girls in Africa, after your other very powerful lecture. But before we begin that discussion, I would like to ask Candace to share with you a brief video clip. Thank you, Candace.
Women continue to struggle under gender-based violence. This issue of gender-based violence has become a very painful issue to many of us, because rather than see gender-based violence going down, we continue to see incidents of gender-based violence. But what is more troubling is how the men of our country continue to abuse women, not only by killing them, by raping them and brutally killing them, but it gets worse when it actually involves the rape of children as young as a few months, children as young as 2 years, and the impregnation of young girls, as it was being said earlier here by Minister Chikunga. That is painful. And that is why we say we must all rise against gender-based violence. We must all rise, men and women, and make sure that we bring the levels of gender-based violence down. In many ways, many women continue to struggle to go through life. Yes, they struggle to have access to basic services, especially water. Many women in our country.
Thank you, Candace. So we've been talking about this issue. There is participation and concern about this issue. I have to tell you, I was a little bit disappointed when I checked the figures today. This is the first time that we have fallen below 100 signatures. Every other day we've had more than 100 signatures. I think we had about 30 over the last 24 hours. I assume that's just because you're busy. But in terms of the road forward, if you wish to travel this road, because this is your decision. These are your countries. It is for you really to take the lead. I think the petition is the first priority. We have achieved over 1,000 signatures in just a few weeks. That is a very good beginning. But we need to have many, many, many more signatures in order to let the African countries know that this is an issue that many of their citizens care about. So I would suggest that the first priority should be increasing the number of signatures through social media, etc. There has been a request for an online meeting of the coalition. We can do this perhaps in about a month. I hope to have at least 5,000 signatures by then. This meeting will be different. There will be no registration. There will be no reminders. There will be no certificates. You will receive a link to the Zoom webinar about 2 weeks in advance. So watch your emails and also follow the WhatsApp group. In terms of events, there have been several discussions going on at the national level. I think it would be very worthwhile to organize events, and we can talk about this more in October, that bring attention to this problem from the national perspective and that present this convention as the first step towards beginning to address this problem. I hope that you can find venues such as universities, perhaps the Ministry of for Women, something like that, who will provide you with a room and internet free of charge. You can provide your own introduction to this issue from your national perspective. You can show Hajer's wonderful lecture explaining the convention, and then you can have an exchange of views. Again, we can follow up on this more when we meet in October. There's a very active group in Uganda. They are already getting organized to draft letters and yes, this is what I'm working on. I'm going to try to put together a special video for you, which will include, that you can show. I hope to have it ready by October. It will include possibly a statement by the Special Rapporteur for Women, and the statement by the President of South Africa, which I think is very powerful. In another part of his statement, he mentioned that this type of criminality thrives in silence. And so the idea, as he suggested, is to raise your voices, to end the silence. And then I would include the clip from Judge Yusuf's wonderful lecture on Monday, in which he made a very powerful argument about the importance of all African countries signing and ratifying this agreement, then Hajer's lecture, and then a final slide with the link to the petition. November 25th is an important day on the global level. It is the beginning of the UN campaign to end violence against women. When we meet in October, we can talk about whether this would be a good day to galvanize, to bring together the efforts of the national coalitions, and perhaps have a series of events in different African countries on this same day, so that the voices would be heard loud and clear. Also, and I'm going to turn over to Hajer very soon, she has listened to you. She understands and appreciates and shares your concerns. And so I would now like to ask Hajer to let you know what the decision has been made concerning the theme for this year's AU Law Week. Hajer, the floor is yours.
Yes, thank you so much. Again, it is because of your efforts, you know, we were just trying to find the best moment And we thought that because all you said, but because this convention against ending the violence against women and girls came at a time where everyone is concerned, came at a time where we still need ratification of the member states. Member states, maybe they do not know about it. Maybe they are not aware about it. Maybe they do not do enough, politically speaking, for their parliamentaries. Maybe there is also, you remember in my lecture, I said, some of the countries said, we have already Malabo Protocol, Maputo Protocol, why we need another convention. So I think because of all that, in our AU Law Week each year, we try to put the light on a convention, on a draft instrument, on an instrument to encourage the member states to ratify it. The last year we did AU Law Week on Malabo Protocol concerning this fusion of the two courts, and it was really interesting. It was really highly appreciated that we bring together, including Madame Fatou Bensouda, she was one of the speakers, some judges from the court, the actual court, Don Dia, who was the one who drafted this Malabo Protocol, scholars, civil society, etc. And we will do the same this year. And we found, after discussion with Professor Virginia Maurice, that it is the time also to do the same with the Convention Ending Violence Against Women and Girls. So we decided with the team after consultation that it will be the one for this year. This will be our theme, and I congratulate her also for the petition, because you began something. I am discussing about that in my circles, beginning with the Department of Gender. Here we have very beautiful ladies who are doing their best to disseminate, and they are excited with the question. We have also Honorable Judge Janet from the Banjul Commission. She is with this gender portfolio, and she is one of the best people who are encouraging ending violence against women, and she has a mandate, and she will be also maybe one of our speakers, because one of the portfolio is to see the level of protection of women and girls in different countries in Africa, and also the mother of all this process, Madame Bineta Diop, her and her team were the drafters of the draft of the Convention Ending Violence Against Humanity. So it is just to tell you that as Office of the Legal Counsel, we have this mandate to disseminate. AU Law Week become a tradition here. We highlight and we put the spot on such conventions that need that we do a lot so that they can enter into force very quickly. And I think with the petition, with all this positive energy, all this enthusiasm with the convention, we can do the difference, because people will be aware about it. We can also tackle AUCL, we can tackle organs like the Pan-African Parliament, and through all these organs, it does speak to others. So I think, again, thank you, because you are the one who encouraged me to tackle that as AU Law Week. We will work on it. Maybe we make wrong dates. We will speak about the dates, December or November, but definitely we will just put it on our LinkedIn coming soon, so that you can be invited, the ones who are interested. We still do not know what is the format or what is the country. We are still discussing budget, but the ones who have partners, the ones who can aid, the ones who can assist us, help us, can join. We will do the conceptual note, and we can discuss. I said to Professor Virginia Maurice, we can have online discussion so that we can prepare it very well. But I think the consequence of this will be, it is like marketing. You are just trying to put in advance something that is very important, very urgent, very helpful. And we need to tackle everyone, not only lawyers, as I said. And as she said, these tools aims to go for future generations of our girls and our sisters, our mothers, etc. So let's do it. And I think the momentum is very interesting. This convention is à la mode now, you know. So we can do a lot, and thank you so much, because this was your initiative, but me, I just followed with you, and we are working together. We will tell you about the news and the petition, please, because this is also, you have 400 people on the platform. You have girls, sisters, you have friends. You can help us in the petition. Put it on your WhatsApp, on your LinkedIn. Sign, please. We need thousands of people to sign this petition, because it will make the difference. And maybe, as I said, in fine, 15 member states are enough so that the convention enter into force. We have now the political will of 5 member states. At the beginning, this is good, but we need more, and this could not be possible without your help, your assistance, your enthusiasm, and let's do it together. Thank you so much, Prof. So this is to announce that the AU Law Week will be on the Convention Ending Violence Against Women and Girls. Thank you. You are muted.
Sorry. Thank you, Hajer, for your kind words. We always work together as a team. But in this case, I have to say, this was not my initiative. It was the participants who wrote to me after they listened to your lecture and said, what can we do? What can we do? We want to change things. How do we change things? And I wasn't broader. And that is why in the registration for this seminar, I included a simple question, having no idea what the answer would be. I simply asked the participants, would you be interested in joining a coalition? In about 2 weeks, over 1,000 people said yes. That is what convinced me that there is enough support to make something happen. So I would like to express my gratitude and say how proud I am to work with such an extraordinary group of African lawyers and law students. And you have already made a difference. Do you realize that you had an impact on the decision of the African Union concerning its theme for AU Law Week? Congratulations. Your work is not over, but you are already having an impact. I think, as Don Dea said yesterday, the challenge is you have to keep up hope. You have to keep up motivation. You have to work together so that your efforts are multiplied by all the people you are working with. And again, we have to keep the petition moving. I will see if it is possible to find a date in October when Hajer may be able to join us. And each of the national coalition groups will have a chance to make a 5-minute progress report. So that will be the first hour of the meeting. And then the second hour will be a chance to ask questions, exchange ideas, and to begin to hopefully make plans to have a coordinated event on November 25th, which could lay the foundation and increase the impact and the success of the following meeting of AU Law Week. So Hajer, I have one other announcement, and then I'm going to say goodbye to you because I know you're busy. I just want the participants to know that the African Law Series was a pilot project. It started just last April. I think it is safe to say that this has turned out to be a worthwhile project because of the support that we have received from the most distinguished international lawyers from Africa, who all volunteered their time for us. We have more than 2,000 participants who have signed up to attend these lectures. And I am delighted, honored, and it means so much to me that the AU Legal Council, Hajer, also believes in the value of these courses, and she believes that they should continue. She will be signing your certificates this time, and that means a lot to me, and I hope it also means a lot to you. Hajer, I have some just administrative announcements to make as we end this seminar. So do you want to sign off? Should I say goodbye to you now?
Will be done. Thank you so much. It will be done. Congratulations. You are really doing great. Just by yourself, you are doing the how to say, what organs are not able to do. So really, I'm really impressed. Thank you so much. You can count on me. I'm with you. I will sign, as you said, co-sign the certificates, and let's keep in touch for the following steps. Thank you.
And I hope you can join us in October. Let's try to find a date for the next
Yes,
coalition
so-
meeting. Okay.
Yes, we will do that. Thank you.
Okay.
Bye-bye.
Thank you, Hajer. Dear participants, we're running a little over. I just wanted to remind you that yesterday, Don Dea, the CEO of the Pan-African Lawyers Union, has also recognized
Sorry, Virginia.
the
I think Ben is also wanting to say goodbye.
Oh,
before we
Ben.
continue.
Okay, Ben, come on. Where are you, Ben?
Yeah, I'm here. Actually, thank you. I didn't want to say goodbye. I wanted to share an experience
Please.
with regard to the protocol on the rights of women. The Malabo,
Candace, can we highlight Ben? I can't really see Ben.
Yeah, so
I can't see you,
Sorry?
Ben. Just a minute. Okay, now I
Okay,
can see you. Okay.
give me a second. Give me a second. Yeah, okay, I'm here. I wanted to share an experience with regard to the ratification of the Maputo Protocol on the rights of women in Africa. The women groups organized themselves and came up with a very interesting initiative that was very effective in the end. What they did was during the African Union Summit, they would confront delegations, particularly at the head of state level. So states that had signed the protocol, they would have a very big sign, amber. Okay, if you have signed and ratified, it will be green. If you have neither signed nor ratified, it will be red. And they will be on the corridors of the African Union Summit and holding these cards with the color indicating what the state has done or not done. And you can imagine how embarrassing it is for the heads of state. So you would have a situation where ministers would be trying to get themselves to avoid a situation where the heads of state will be embarrassed. So that is very effective. It was very effective. We managed to get a lot of ratifications during that particular summit. The other thing, that is one idea. The other idea would be this petition somehow needs to get to the heads of state and the ministers of foreign affairs and those in charge of women, because that's where then you are going to get some action coming through. If you have a conference of senior officials or parliamentarians, it's useful, but it's not as effective as when the head of state is confronted with this issue or the Minister for Foreign Affairs is confronted with this issue. So we need to include those aspects into the campaign. Thank you.
Thank you very much, Ben. Maybe you can join us when we have our coalition meeting because your experience with these issues are very important. The petition lists all of the signatures. And of course, you and Hajer are at the top. And as the coordinator of the petition, I can print out the entire list of names. And it can also be organized by country. And the very active coalition in Uganda is already talking about this. They are working on draft letters to send to key government officials, policymakers, decision makers, such as the head of state, the Ministry of Foreign Affairs, and the ministry that is in charge of women and girls. So I will see if I can coordinate with you and Hajer and of course Candace, and see if we can come up with a date in October when we can have an informal meeting. Again, give the national coalitions a chance to report on all of the progress they have achieved, and then allow an hour for discussion, brainstorming ideas. And I hope you will join us because I think we need our own panel of the wise, so to speak.
Okay.